Legal Tech for Africa. Wivo Legal Tech for Africa. Wivo Legal Tech for Africa. Wivo Legal Tech for Africa.
Good evening, Africa and beyond. Welcome to another episode of Wivo Legal Tech for Africa. I am Mohamed Ogiba, and today we will dive deep into something huge. In a digital galaxy not so far away, where surveillance capitalism reigns supreme and data flows like currency, the empire led by the big tech overlord has long dominated the digital skies. Their algorithms know more about us than we know about ourselves, and their influence stretches to the deepest corners of our personal lives, economies, and even our democracies. But every empire invites a rebellion. Tonight, we shine our lightsabers not in fiction, but in legal reality. A brave group of rebels, armed not with blasters, but with legal tools, constitutional rights, and the Data Protection Act of Uganda, have risen to challenge the might of one of the most powerful entities in the digital empire, Google. At the end of this resistance is Frank Ssekamwa, a human rights lawyer and digital rights activist. He is one of the applicants in a landmark case that dare to ask, can African citizens push back against big tech? Can local law triumph where global giants believe they are untouchable? Joining me today is Frank Ssekamwa. Frank, welcome to Wivo Legal Tech for Africa.
Thank you, Uri. I am happy to be here.
Perfect.
And
Yes.
good evening to the viewers.
Great. So tonight we'll explore the journey of Ssekamwa and others versus Google LLC, from the root of the resistance to the courtroom clash, and what this means for the future of privacy, sovereignty, and justice in Africa's data landscape. This isn't just a legal discussion, it's a frontline report from the data wars, and you are highly invited. So let's set the stage, Frank. What was the specific context in Uganda that led to this case? Why did you guys decide to rebel against the empire?
You're using big words, my brother. But yes, I would say we are rebelling. But anyway, yes, it's a lot of things that led to the case.
Yes.
And most of them are actually determined by our actual realities, experiences, and histories, and yes, our way of living in Africa. So the case started as an individual thought that I came up with, but it came from the work that I am doing at Afya na Haki Institute as a researcher, where I implement most of the digital health projects, but also at Makerere University, where I am a Master of Laws candidate. And in my research, I'm exploring the intersectionality of digital tools and human rights. So that's how it comes about. And in our preliminary research, we found out that there were so many legal, policy, structural, systemic issues that needed to be addressed, not just theoretically by writing our thesis and just shelving it, but practically to have some sort of implementation research. And that's how it comes about. And with the guidance of my supervisor, Dr. Businje Kabumba, we said, what strategic way can we think about and come up with something impactful in terms of methodology, but also in terms of a solution, finding a solution. So we found out in one of our preliminary findings that yes, there was some impunity by big tech. So they could not comply with the law in the guise of jurisdictional issues. And second, we found that there was a problem of mindset. Our people do not really prioritize data privacy protection as a big thing, and it comes not because they do not want, but it comes from an intersectionality of so many issues, including power, including ability, because they've not been given the platform and the energy, and the support. So there were so many things, and we said, let us do something. And so for me as an individual, I knew people that were like-minded and had the potential and commitment. And that's how Waleni Shaoni Pamela, Raymond Mpaire, and Mase Awino came on board. So I had to look for them because, in Africa, we work as a collective. We are Ubuntu. I am, because we are. And also to balance the board, we needed to have voices. We are gendered, and also we come from different regions in Uganda. So those regions had to be somehow represented. So it couldn't be just a one man's army, otherwise we wouldn't have achieved. So, and those are just a few people that I have mentioned, but it's a collective of a lot of efforts from different people.
Perfect.
I hope, yes, that
So
helps.
perfect. Yeah. I mean, that's a lot of work going on down there.
Yeah.
So where exactly? You've mentioned impunity and you mentioned big tech, but in this instance, particularly, you brought an action against Google, and then, of course, in our arena, in our field, we consider Google as the empire because of how vast the platform is. So, what exactly did Google offend? Who did Google offend, or what law did Google offend that you and your colleagues decided to institute an action against them? Give us a rundown.
Okay. So I am, besides being a law student, I am a trained lawyer, certified, and I'm an advocate of the Supreme Court and the subordinate courts. And so I have been a data protection advisor to so many NGOs and companies, small as they are, and they are required to comply with our data protection laws. And for big tech, they are able to get away with it without any sanctions. So basically, we have a law in Uganda. Our major law is the Data Protection and Privacy Act of 2019, now CAP 97. One of the fundamental things it has, it requires every data collector, processor, and controller to register with it. And that has so many implications, because when you're registering, you have to expose yourself to the data protection office, personal data protection office that is established by that law. Okay, so the moment you register with it, we expect you to be at least compliant with human rights, with our national standards. And so, and once I noticed that most of the big tech companies are not registered, and yet here in
So,
Uganda you can.
so you said most of, and can
Yes.
you give us examples of these big tech companies that are not obliged to the laws or the Data Protection Act of 2019?
All right, I think every big tech company, including Meta, TikTok, Google, and why I and my colleagues decided to take on Google specifically is because just a preliminary assessment will show you that most Ugandans, Google is the largest data collector in Uganda. So people use Gmail, use Google Maps, we use calendar, we use everything, Google Health Tracker.
We use YouTube.
We use YouTube, we use Google Meet. Everywhere Google is taking each and every aspect of your data, be it demographic, be it sexual, be it health. And so strategically speaking, we said, who now can we bring to this area, and to the data, to the precincts of the law, to be accountable, and yet they would be representing a diversity of so many actors. And you see, now that we are talking about AI lately, we are using Gemini every now and then. And so, as complainants, we had to situate ourselves as data subjects so as to get that locus standi, to be recognizable under the law that indeed we can bring an action against Google. And yes, as I've told you, we are users of those products. And so it was very, very easy for us. But we did not file this case on only on our behalf. We filed this case on our behalf and on behalf of other Ugandan users. So it's a collective action. And this is something that had never happened before.
Perfect.
I don't know if you understand. So going back to my previous introduction, where I told you that there was a problem where our people were not asserting their privacy rights, we said yes, but if it's there, we know they cannot do that because they are facing challenges. Can we do it for them in a strategic way? And that's how the case comes about.
Okay. So now I want us to be specific.
Yes.
There is a law in Uganda that's
Yeah.
obliged big tech companies or whatever controller or processor
Yeah.
in the mix to register, right? And in this instance, from your submission, you said Google failed to register, and you think they did so with impunity. What was the role of the government, in ensuring that before even you guys brought the action to the court of Uganda? Did the government or the government agency, that, I mean, like, for example, the Data Protection Office, you have a DPO, right? What was their role in ensuring that this impunity, before you guys brought the action, couldn't have happened?
Okay, first of all, for government, it's just, and let me just go back a little bit. We were not witch hunting Google specifically. We just wanted to use at least one of them as an example. And so Google happened to be one of those most influential companies.
So Google is the lab rat.
And so, yes. So it has not really been, we didn't expect it to fail to comply. So our law that the government enacted in 2019, and for the government, once it enacts a law, I think it has done some work. For you as an actor, once you come to the jurisdiction, you have to find out. You have an obligation, because as a lawyer, you understand ignorance of the law is not a defense. And second, as complainants, the data protection officer requires us as a mandatory requirement before we file a complaint before that office to demonstrate to it that we have tried settling the matter amicably. And we reached out to Google, we tried. And I wanted to let you know that this case was not just a legal action. It was about so many issues. It was about sovereignty. It was about decolonization. It was about independence. And so on the 9th day of October, it was 2024 last year, I wrote to Google because that is our Independence Day. So we thought, being strategic, why don't we use this Independence Day and then start asserting our independence in terms of data sovereignty? So that's how we start now reaching out to Google using all its platforms. Unfortunately, for all its employees, it has a very, very strong policy. We have friends that are employees there, but they could not even, they even cut ties with us. It was a big risk. We lost friendships. So whenever we tried to ask them who can we contact there, nothing. So we could only get automated emails. And
wow.
So unfortunately, even when we filed, our personal data protection office tried for several months to reach out to Google. Google wasn't responding. And it has an office here, just near here in Nairobi, Kenya. but it wasn't responding. That's why we say it is just impunity. That's why we had to move on with the complaint. So basically, those are the contours, those are the procedures that the government has set out, and those are some of the things that the government did. As complainants, we did our role, but also government proactively did its role by enacting the law, but also the Personal Data Protection Office following up every now and then. And it's an untold story how Google came about. And for us, for me, it is the most celebrated win in this in this conversation. Getting Google to submit to Ugandan law was not an easy thing. We had to struggle, we had to waste resources, we had to risk, as I've told you, so many relationships. We had to risk it all to get there. We even had to file a case in the High Court.
Wow.
And that case is still there. So, and it maybe did something. So we needed to have some active advocacy, activism to have Google come here. So it wasn't just a walkover. Suing multinational companies is not an easy thing. Even for the Personal Data Protection Office, our data protection authority, it's not an easy thing. Even elsewhere, enforcing cross-border complaints is not an easy thing. So for me, bringing Google to submit to our jurisdiction, for me, is the most celebrated achievement. And I would like to applaud the Personal Data Protection Office in the leadership of Mr. Baker Kuja for really trying so hard. We were on their neck. We had to even sue them together with Google, the Attorney General, the ministers. People had to act because there was some pressure.
Perfect. I mean, it's so emotional.
Yeah.
So, if we can summarize what you have said, the Google,
Yeah.
You brought an action against them because of one, unlawful data collection. They have so many mediums, like you have established, and also they failed to register as a data controller or processor in Uganda, which violates your Data Protection Act of 2019, right? And then you also mentioned the issue of non-consensual sharing or profiling, which also violates provisions of the data protection.
The act, just
the act itself.
Yes.
So this you also mentioned the struggle of getting the attention of Google, and this brings us to the question of digital sovereignty. In your estimation now, I mean, imagine this is not only for Uganda. I believe this is happening in many other African jurisdictions. The GDPR is very strong. I don't want to compare us to the GDPR, but Google will never do such a thing to the European Union. Yes.
Can I first address something, because I feel like I will not be able to come back to it where we are going. Please, could you allow me do that?
Sure. The platform is yours.
Yeah. So our case was about two things.
Yes.
It was about the non-registration, because we knew strategically that if we could get Google register, it would then solve so many issues. Second was the transferring of data abroad without complying with our national local requirements.
Perfect.
And that was basically motivated by the Schrems decisions. There it was determined that Google data from the EU wasn't safe in the US. Yeah, so we had to slot in that, but also access to justice for data subjects that are this side of the continent. If I want to come to bring Google to account, how fast will my matter be addressed? So will it even be given any attention? So that was it. It wasn't about so many things. At first we thought about so many issues, but yes, we said strategically speaking, because as a lawyer, once you mix issues, you might lose.
Mm-hmm.
So we had to make our case very straightforward and as easy for everyone to understand and not to confuse our case. So yeah, just wanted to clear it. So it was about non-compliance with our
Mm-hmm.
law in that
Mm-hmm.
regard of non-registration,
Mm-hmm.
and then transferring data without complying, and then secondly, violating our rights. So it is about non-compliance and violation of rights.
Mm-hmm. So now
Because we believe that once it takes data outside the country and once it collects our data without complying with the law, we believe that so that causes distress on us, wondering what Google is using our data for. It's a big company, it can easily comply with the law without even feeling the resources, okay, of
Mm-hmm.
compliance, the cost of compliance, but it is refusing. Why so? So we feel distressed. And so, and when we come to it to get some redress, it doesn't give us attention. So by doing that, it is violating our privacy rights. So that's the case for you, my brother.
So you see, that is why I asked you a question just now. What did the government
Yeah.
do initially before you guys even decide to bring the action against Google? And I'm happy you responded in the affirmative, because that is not the case for so many other countries in Africa,
Yeah.
including my country, which at the moment has no data protection law. And you said,
Oh.
yes, you said your country in Uganda had a data protection law in existence since 2019. That's 6 years now. And then you also mentioned the role of the data protection officer and how he tried to get the attention of Google. So this takes us to collaboration with the public sector, the private public sector collaboration, which is not usually the case for us in Africa. And because in the GDPR, we've seen, in the European Union, we've seen how the GDPR has ensured compliance from all these big tech companies. But we do not have that privilege in Africa, save for few cases like yours. So in your estimation now, what do you think, what can we learn, especially from the government side, from you guys, and then what can we learn from your advocacy, you and your colleagues?
I think beginning with government, it's about putting the laws in place and enacting the laws. It's very fundamental, because it gives everyone that assurance that at least their rights are recognized. And so it also gives them a platform, so someone knows that if this is not done, because the role of law as in law, just it had some rights have to be defined and
Mm-hmm.
obligations have to be there. So once you have a law, it's okay. So I feel like this sets an example for other low and middle income countries, governments, to set up data protection laws if they have not set them up. And also to establish data protection authorities that are functional. I do not want to castigate my government, but it's not funding our office well. And that's why, for a case that had to be resolved within 30 days, working days, it took us almost 10 months.
Wow.
Because our data protection office receives less than 100 million Ugandan shillings for its annual budget. It has less than 5 employees who are on government contracts. And yet for Google, it's making billions of dollars annually.
Yeah.
You get, and you expect this entity to. So whereas the government established the Data Protection Office, it's not enough. And this is a lesson that other jurisdictions should learn from Uganda. In Kenya, where the Data Protection Office, the Office of the Data Protection Commissioner, receives almost 6 point something million US dollars. That was very easy. It was very easy to enforce against Google. In fact, there was not even a complaint. The Data Protection Office just required it to register, and it registered instantly. Good. So empowering the data protection authorities by resourcing them adequately, it's very key, and it's a lesson that we learn. But also as a best practice, proactiveness. Our data protection office it worked very hard. It had to collaborate with so many offices in Canada, Sri Lanka. I think I've heard this story, but it's amazing how we finally got a contact that linked us to the person at Google. But also even Google itself coming and submitting
To the court.
to our jurisdiction.
Yes.
It is not something that should be underlooked. I think not just only government and us, but also other tech companies, data collectors and controllers should learn from Google that yes, once you're benefiting from a jurisdiction, you're obliged to comply with their law. Once they call you, at least come and listen to them. Don't act with impunity like a colonial master, how those people used to do. Okay, because we end up mistrusting them. And for us, because of our history, slavery, extraction, colonialism, okay, for us, and it makes us doubt everyone's intentions. And once you also behave in a way that makes you suspicious, my friend, we will not trust you. And this is where it will all go. It won't go well. But also, now I'm not going to blow my own trumpet. You say our own advocates, how should people learn from us? But you see, we have been some of the people have castigated us as the biblical David versus Goliath
Goliath. Yeah.
the situation. Yes, it happens, and you lose a lot. You have so much to lose at stake. But as an activist, activism does not come on a silver platter. It comes with sacrifices. So maybe what our colleagues, activists from the entire world should learn, I know we should also learn from them, but from this case, they should be resilient. They should learn how to bang the tables. You know, in our law society lately, our law society president is requiring us to bang tables. You bang tables and you get your heart. If we had not sued, if we had not done all what we did as a group, then maybe we wouldn't have gotten anything. And not moving alone. They say that if you want to get to where you want to go, you move as a group and you move maybe slower. But if you want to just move, you move fast. You can move alone and don't reach where you want to go. So just moving collectively, keeping the African tradition, the Ubuntu tradition, it helps, because sometimes I'm in office and the data protection office wants us to do something. All we want to serve a letter, and Raymond will do that. Sometimes I'm busy, and Marseille, Lenny, they will look at that response. They will draft a letter, and we'll just review as a group. Okay, sometimes you cannot do it alone. You realize you're out of timelines, you realize you're out of resources, you're out of connections. But also having a fair representation in your work. So I am from from central Uganda. Len is from north. someone is from West Nile, and then Raymond is from Western Uganda. Each of us has a particular audience.
Yeah.
We have our own audience, people that believe in us, that can look at us and say, yes, I'm coming on this to this cause because of so and so. And also someone might look at Lenny, because Lenny is a feminist, and joins the what, the cause because of Lenny. So in most cases, as an activist, you don't do it alone. You have to make sure that at least you have a fair representation of your communities, people who can resonate, people who have felt the issues, who have lived them, because I could not come here and claim to be an expert on the data privacy issues affecting women in our modern world. You get, but Massey is there to speak to them. But also Massey was also has ever worked with the Data Protection Office, so she would tell us exactly what used to happen there, and we could feel some issues. Sometimes we could press the Data Protection Office, but some Master would say, guys, this is what is on ground. There is only one compliance officer who is handling all complaints from the entire Uganda. Let us not be selfish and have that the sense of entitlement that we are the only ones that are there. So we could somehow take a step back because of that, understand the context. So yeah, I feel like that's one of the things that people should learn from.
All right, Frank.
Situation.
I mean, we've been talking for a while now, so I want us to catch a break, take a sip of water, a minute's break, and we'll come back and look at the conduct of the trial itself, because I want to learn one of the few things that you guys did to be able to bring Google to their knees, to subject to the jurisdiction of Uganda. So we will go for a minute break, and we'll be back. And when we come back, we'll continue discussion. Don't go anywhere. Stay tuned.
Wivo, legal tech for Africa.
Welcome back, viewers. If you're just joining us, we are with the company of Frank Ssekamwa from the beautiful city of Kampala. And we are diving into their stride in bringing Google to the jurisdiction of Uganda for failing to comply with the Ugandan Data Protection Act of 2019, and therein by failing to register as a controller, a processor, and then processing the data of data subjects in Uganda without complying with the requirements of the law. Ssekamwa, so now we've done much of the background of why you guys decided to bring Google to court, and one thing that inspires me from your discussions this evening was that this is not a witch hunt or something a stride to get something out of Google. This is because as a human rights lawyer, you think Google is violating the rights of the citizens of Uganda, and they were doing so with impunity. So that is why you decided to bring an action against them. And even before instituting the action against them, you tried to reach out, to see if they can comply without bringing the action. But that those cries fall on deaf ears, and then you had no other opportunity or something else to do, but you have no decision option was to bring an action against them. So
yeah.
During the conduct of the trial, who represented you guys? Were you represented per se, or did you consult the services of a law firm?
So that's a good question.
Yes.
As I indicated, it started as a student initiative.
Mm-hmm.
And I personally, I have worked with several law firms. I've also worked with the court, the High Court of Uganda. And so I know what a lawyer should do, and I know what the judge wants to get from the case.
Mm-hmm.
And second, at Afya na Haki, where I'm working, I have spent almost 4 years of doing strategic interest litigation, not as an organization, but we support our partners to litigate strategically. And we have some of the most outstanding judgments on sexual and reproductive health in Africa.
Mm-hmm.
So having all that experience, at first we thought we didn't need services of a lawyer. So we went all in by ourselves at first. And so, but because each one of us comes from a particular law firm, that helped us. And at last, we had to get services of a lawyer, because most of us now, Mercy is in South Africa studying. I would be on running so many errands. Lenny is also always busy. So we had to get a lawyer. But this lawyer had to always do what we've told them.
Yeah, I understand. I mean,
because for lawyers, we tend to look at things in a very legalistic way. Someone will not look at this case, because everyone will tell you go to court, because the Data Protection Office, the Personal Data Protection Office, does not have powers to award compensation, doesn't have powers to issue sanctions and enforce them. All it does is to give declarations. So as complainants, you again find ways of enforcing them, including going to court. So most lawyers think that going to court directly is the most straightforward, and indeed sometimes, but not in terms of advocacy. This case would not have achieved the magnitude it achieved if we had taken it straight to the court. Remember, I told you in our research,
mm-hmm.
when we were conceptualizing the case, we wanted to use it as an approach to find out what is happening practically. If I am a data subject trying
Mm-hmm.
to enforce my rights,
Mm-hmm.
what kind of experience do I go through? We wanted to experience that, and then to use the case as a solution. So many things. And yes, the case had to bring out so many things. We've always been ranting, oh, the Data Protection Act doesn't give our Data Protection Office powers to do such and such, and everyone was just shunning it. But now it's on record. which means that it is going to influence evidence-based advocacy
Mhm.
and also evidence-based policy making. And from here, we are going to Parliament to tell them, look, we just have declarations against Google. If you had empowered our personal data protection office, we would be having enforceable declarations straightforward. Now we have to spend other resources and time to have Google comply. If authority refuses to comply with the declarations, we will have to now to escalate the matter to court, which is unnecessary, because why would we have a data protection office that is just like a proverbial dog that just barks and doesn't bite, cannot bite? Would you run away from a dog that you know it doesn't have teeth
No.
and claws? You wouldn't. And so that's where we are coming. That's where we are coming. So we went to the data protection to the personal data protection office because we wanted to find out exactly what are the experiences that people go through, but also what are those structural systemic legal policy issues that we can unravel, but also address using the case. And so for a lawyer who is a mainstream lawyer, not having an activism and advocacy perspective, would not go to that office. But now we have activated the office. And actually, what I did say before, because it is under-resourced, our data protection office, it has not been resolving matters on time, okay?
Mm-hmm.
And also not resolving 100%. Actually, it has been resolving just 5% of the complaints that come before it. And so most lawyers think that perhaps going to court would help. But trust me, if we had gone to court, we would not have had a judgment by now. But we were able to secure a judgment within just 10 months, which is a record time in our jurisdiction, where you can have a case run for 10 years. Also, you get. So we wanted to show the public that, look, there is this avenue, it can work. Now that it has worked, but it has some inefficiencies, let us now try to work backwards to address them. So that's it. We had a lawyer, and I would say lawyers. One of them is Banachita Johnny. He's from Ssekamwa and Company Advocates. We had Calivayo Blair, who is Orima and Company Advocates, and we had other people. One is from I don't remember the law firm's name, but people have come because the four of us, each one of us comes from a different law firm, and so we used those law firms to represent us once in a while.
Okay, so Google also consulted the services of lawyers in Uganda, right? Just to get.
Yes, please.
Okay, I mean,
yes,
you're
please.
fine. All right. So now.
So that was AF Mpanga.
Okay.
And we are happy that we created work for other Ugandans.
I see. I mean,
yeah.
Again,
Yeah.
one major important thing I want to clarify quickly. I mean, because these endeavors are very expensive. Did you have initial funding to pursue this?
Initially, we did not have it. We used our own money. We used our own monies, but after some time, now, because I told you I ran most of the digital health work at Afya na Haki, we have a project called There Is No App for This Project. It is funded by the Wellcome Trust through the University of Warwick there in the UK. So we were working with the likes of Professor Sekalala. We had some money, but you know, it's a reimbursement project. You have to first spend and they will refund you. So it was somehow tricky in that regard.
And
after some time,
mm-hmm.
and after people had seen the light where the case was going, they started. So from that project only, but I will not say that the funding was enough to do everything. We had to economize.
I can understand. I mean, I clearly understand you. So now let's quickly look at the consequences and implication of this decision this declaration.
Yeah.
What are in your estimation, what do you think you guys have achieved?
Oh my, we have achieved a lot of things with the case.
Mm-hmm.
And one of my colleagues told me, look, guy, my friend, the case is now bigger than us. We can't control the narrative. And that's why this is our debut appearance. This is my first time to come out ever since the judgment came. People did not know my face. We had to let the case drive itself because it was crazy. You get it was
it's an
crazy.
honor to
So
have you here as a deputy.
yeah, so everyone is publishing about the case. Everyone is welcoming the case. Of course, there are those voices that are saying, look, there's this and this. But yes, we appreciate them because it is through criticism that we become better people. We become better human beings. But as you've rightly said, this case has its own impact in terms of bringing out the defining the legal principles in Uganda. So now now data collector, be it big tech companies, they know that in Uganda, compliance with human rights standards is not negotiable. It also sets it changes the power symmetrics. Look, back then it has been the big tech companies that have been defining how they could comply, and then our regulators would just follow. It's been more of self-regulation. Now it has to define, because you see, Google was saying it is not ready. Then our data protection officer said, you have to file your response within a week. Otherwise, we are ruling this matter ex parte. They complied. We are defining. I talk about sovereignty. You get, we are we are saying, we are showing that Uganda is in charge. No matter how big you are, we are in charge. If you're collecting the data from our citizens here in Uganda, you're subject to our law.
Mm-hmm.
Google had to plead on so many things. And I think it's about resistance. It demonstrates resistance. People have started filing so many cases, including against our own government, because now they understand. They are now empowered. It's resisting the colonial tendencies,
Mm-hmm.
the unjust tendencies, the injustices, the unfairness in surrounding data protection. People have started, and for me, I am very, very happy. People are reaching out, asking me, how can we enforce the decision from the Google ruling? I'm like, you will see. We've been having those chats. People are reaching out, and I'm seeing people have tweeted, people have published about this case, and I am so happy and honored. And when you reached out, this is one of the impacts. The
Yes.
space.
Yes.
Yes, you know about the case, and now you're in the UK. You have the Syrian audience. These people are knowing. Our data protection authorities are also emulating this.
Mm-hmm.
You get, our data protection authorities on the continent are emulating us.
Mm-hmm.
They are like, hey, if Uganda can do it, why not us? So now they are ceasing to be just symbolic offices, but to demonstrate themselves as offices that have adjudication powers, that offices that can define things. So for me, it's about a multitude of things. It's about resistance, it's about decolonization, it's about awareness, it's about mindset change. People are changing their mindset. People used to look at data protection as something very fancy. Most
Mm-hmm.
people, but now people, even my colleagues, every time they see something data protection or they see something, they will call me. I have been in conferences. Last time I was in a conference of the Association of Medical Councils, and these regulators were coming to me asking me what they should do. But now they realize that even their health sectors, their professionals have to comply,
Mm-hmm.
because if Google can come down, then why not you? And maybe if Google could come here, people now would start imagining or thinking about data protection or data privacy in a different perspective. So briefly, there are multiple of things, and if I started talking about them,
I know.
we will not even finish.
Yeah.
But yes,
Yeah.
sorry, it's about rain.
I mean, yeah.
how
Let's wrap up now. But before you go, one
Yep.
last thing. Let's critically. I mean, the majority of African nations, because prefer fostering innovation and technology as against protecting the rights of the people. For example, we embrace new tech. We want we. I'm just giving an example. We want Starlink in our cities. We don't know the implications of Starlink and what it does to the people, or Google or Meta. I mean, the data they collect from our people on a daily basis. We prefer the services than the protecting the people. So there is these two elements fighting each other: the elements of fostering innovation and tech, and as against the protection of individual rights. So, as a human rights lawyer, what would be your take on that? Hello, Frank. Viewers, I think we may have lost Frank, as he clearly said. The weather was getting bad back home in Uganda. But that was Frank Ssekamwa. He was with us, and he was giving us the rundown of a landmark decision they had against Google in Uganda for want of compliance of the Ugandan Data Protection Act. I mean, Google failed to register as a data controller and processor, and also they failed to, follow the requirement of processing data of data subjects in Uganda. So this has been your program, Wivo Legal Tech for Africa. This is where we draw the curtains. Unfortunately, we were not able to get the last words from our guest today due to disconnection. And as he was saying, it wants to rain down there, and so it was hard. The connection was fluctuating. So until we meet again, I have been your host, Mohamed Ugiba, signing out, saying bye-bye. Thank you very much for tuning in.